Hello, everybody. Thank you for joining. I am Kimball Parker. I'm the CEO of SixFifty. For those of you who are hearing about SixFifty for the first time, we work with the law firm Wilson Sonsini to automate the legal documents that a lawyer would typically write for you. So instead of paying a lawyer $20,000, let's say, to write a policy about complying with Biden's new vaccine and testing order, and then getting it a month later, we can do that for you at a fraction of the cost and in the same day. And it's backed by one of the best law firms in the world. So our service is like TurboTax for very complicated legal documents. So that's who SixFifty is. Today, we're going to talk about President Biden's new order regarding vaccines and testing. So last week we had a webinar that talked about the contours of that order. So if you're curious about what the order may contain or may not contain, and some of the details around that order, you can watch our webinar from last week. Today, we're going to talk about what the order means for companies. Like, what are the implications what are going to be the implications of the order on businesses? And there are a lot of them. The law applies to companies with over 100 employees. And it's a big deal. It forces companies to collect some pretty sensitive health information, either the vaccine status of their employees or weekly testing results. And, a lot of people have wondered, how can we do that in a compliant way? The mandate really forces companies to swim in a cocktail of different regulations, privacy, employment, and it's a tricky path to navigate. And so, what policies do you need? What policies and procedures do you need in place? What do they need to say? And we're going to talk about some of the legal challenges that we expect to the law as well. So you're going to hear from an incredible group today. First, you're going to hear, I guess in no particular order, but the first one that I'm going to introduce is Ryan Parker. Ryan graduated near the top of his class from the University of Michigan, one of the best law schools in the nation. He then clerked for 2 federal court judges, one in Michigan, and then a circuit court judge, which is right under the Supreme Court in Delaware on the Second Circuit. Was it the Second Circuit or the Third Circuit, Ryan?
Third Circuit.
Third Circuit. Okay, there we go. So on the Third Circuit. And this is the most relevant. Ryan then worked for the Department of Justice in their federal programs branch. And what the federal programs branch does is defend federal initiatives just like this one against lawsuits. And so you're going to hear from Ryan, who used to defend programs just like this, who used to be in charge of that for the U.S. government. You're going to hear his take on the type of lawsuits that we would expect, and what those will look like challenging the law. So Ryan will also talk about some other subjects, but we're really hearing from an expert here with some inside knowledge there. Second, we're going to hear from Marie Colbeth. Marie, just like Ryan, graduated near the top of her class from one of the best law schools in the nation. Also, like Ryan, clerked on the federal circuit, which is just below the Supreme Court. She taught at BYU Law School, and that's where we snagged her away. Marie, just like Ryan, very impressive. And the final person is Adrienne Jack, just like the other two, graduated near the top of her class from Northwestern Law School, which is one of the best law schools in the nation. Worked for some of the biggest, most prestigious firms in the nation in Washington, D.C. We snagged Adrienne away as well, and now she helps us build our legal products. Adrienne specializes in employment law and building automated employment tools. So our product, our return to work product, which creates all the policies you need to manage all the COVID regulations, and that was automated by Adrienne and Marie and Ryan, but kind of headed up by Adrienne. So some good perspective there. Okay, so a few final thoughts before we dive in. Like I mentioned, we've automated the policies and other paperwork that companies need to manage the layers of COVID regulations. we are incorporating Biden's order into that offering. And so if you're interested in learning more about that product, you can visit www.sixfifty.com/return to work. And we're going to put that in the chat. There you can request a demo. You can see the tool, see how it works. I think it's going to be pretty important here for companies, especially in light of this order. Next, please put your questions into the Q&A and not into the chat. It's a little easier for us to answer them in the Q&A, and then we can catalog them and address them even after. If we can't get your question, we can address them and then send out an FAQ. So if you could put your questions in the Q&A, not the chat. It's not the end of the world if you do it in the chat, but Q&A is better. Okay, so with that, let's turn it over to the triumvirate of employment knowledge here. Ryan, Marie, and Adrian, take it over.
Okay, thank you very much, Kimball. We are really excited about this webinar. I think there's some really interesting material here, and we look forward to input from you. Feel free to put questions in the Q&A. We'll answer them as we go along, and we also have some time allotted for Q&A at the end. Just as an introduction, I do want to say that we'll be touching on some issues that have become somewhat political. We're going to try to steer away from the political part of it and just give you sort of a take on how this can affect businesses and what we're likely to see in the litigation and how that may affect your business. We'd ask you also to try to steer away from the political, and we'll do the same. I'm really excited to start out and talk about potential ETS litigation, but why don't we just look at our agenda for a moment. We're almost through the introduction. I'm going to talk to you about potential legal challenges. I think there's some really interesting developments, and we'll certainly see a lot of action in that area in the coming weeks and months. And then we're going to move on to vaccine policy options and best practices, collecting and storing information. Then there's that Q&A I talked about, and then we'll wrap up. So why don't we dive right into potential legal challenges? So there are a couple of things I want to start out with. The first is we are going to have legal challenges. Just in the last week, 24 Republican attorneys general, so from 24 different states, have already threatened to sue in a letter to President Biden. And we'll send the slides out. I've hyperlinked to that letter. You can look at it. It's a letter that reads a little bit like a legal brief. I do think it's interesting, and it shows a little the political nature of this issue that only Republican attorneys general have signed that letter. But I think that we'll likely see suits not only from states, but also from businesses, right? The ETS will apply to businesses with more than 100 employees. I think we'll see suits across the country, and I think we'll see a lot of suits concentrated in states that typically lean right. I would be surprised if we don't see a significant number of suits, for example, brought in Texas. We have already seen our first suit. The Attorney General of Arizona quickly hurried to the federal courthouse to file the first suit. He then held a press conference touting that he had filed the first suit. The only thing missing from his brief was a link to his webpage that asked for money for his Senate seat race, which was, his suit is very premature. It was a bit of a publicity stunt. His theory of the suit is a novel one in that he claims that citizens and those who have entered the country illegally are having their equal protection rights violated because they may have to be vaccinated or tested at least once a week, while those who enter the country illegally are unlikely to be subject to the same requirements. I don't think that's a theory that's going to hold up. I don't think it's one that we'll see in very many of the suits, but I do think it's a nice example of some of the political suits that we're likely to see. All that being said, I also want to emphasize that these types of suits can be successful. As Kimball mentioned, I defended the federal government from suits like this for about a decade, and sometimes we won and sometimes we lost. These types of suits can be successful. We have seen one already, a similar challenge brought in federal court in New York to challenge the state vaccine requirement that medical workers be vaccinated. And the federal court there enjoined enforcement of New York's rule. And that's initially, so it's not a ruling on the merits, but initially enjoined it because there is no religious exemption. Now, that won't be an issue for the federal mandate, but I think it does show that these types of suits can be successful. And so it'll be interesting to watch what happens. let's dive into what is likely to be argued in these types of suits, and we'll just go through a couple of different things. First of all, let me say that we have only heard very preliminary details about the ETS, and we're waiting for OSHA to issue a much more detailed emergency temporary standard, ETS. And once that is issued, I think that's when we'll start to see the legal challenges. But here are some of the challenges that we're likely to see. There's been a lot of talk about the Commerce Clause. The OSHA Act is what empowers OSHA to be able to create ETS. And there, I think, are going to be questions about whether Congress really has the power to sort of give OSHA, delegate its authority to OSHA to issue ETS. I think there could be equal protection clauses. That's what we saw in challenges. That's what we saw in New York. Those who have medical conditions that may preclude them from being vaccinated or sincerely held religious beliefs, we could see different challenges on that front. It'll be interesting to see how that plays out. The ETS, and we're not going to go into super great detail about the contours of the ETS. That's something we covered in last week's webinar, but the ETS has a requirement that people either be vaccinated or provide a negative test on a weekly basis. And so those who have a medical condition or religious belief that would preclude them from being vaccinated can always choose the testing option. And I think that that may undercut equal protection clause type arguments. The other thing that we could see there, though, is that if employees are required to pay for the testing, then I think that could provide a hook for that type of claim. The claims that we're most likely to see, in my view, are the statutory challenges. And so, OSHA could go through a regular rulemaking process and put out regulations, and has chosen not to do so here. They've chosen to take an expedited process where they don't go through the regular steps of notice of comment and rulemaking and all the requirements that they may have otherwise, and they're going to issue this ETS. And in the past, courts have looked at these ETS very closely, and the statute that allows for OSHA to issue ETS has two requirements that are often litigated and will certainly be litigated here. One, the ETS has to address a grave danger to employees. And I think it'll be hard to argue that COVID-19 is not a grave danger, but the timing of the ETS is something that I think will be litigated. It's interesting that we're at a point where many Americans have been vaccinated. There are many that haven't, but we have, our vaccination rates are improving. And so it will be interesting to see if the courts want to weigh in on whether COVID-19 still presents a grave danger. And then the second is necessary to protect employees from that danger. And I think there'll be some arguments that these requirements from the ETS are not necessary, or that they're not the best way to address this danger. So I want to look just for a minute at some past challenges that have to ETS. So OSHA has put out 9 ETS in total. 6 of them have been challenged in court. And as you can see here, 5 of those challenges have been successful in either enjoining the entire ETS or at least a portion of the ETS. And so the courts really do take a very close look at especially this grave danger requirement and the necessity requirement. That being said, as you can see, we have not had a challenge since asbestos in 1983. So we're going on almost 40 years since one of these has been challenged. The other thing that's interesting is that these challenges will go directly into the Court of Appeals. And so when we talk about these emergency temporary standards challenges, they typically go right into the Court of Appeals. And so you'll see those filed, these types of challenges in different circuits. Again, I think the Fifth Circuit is one that is likely to see a lot of these challenges. I do think, as I've looked at some of these cases, that there is a stronger case for this potential ETS than some of these past cases when I've looked at the bases for these rulings. And so I think that this is going to be a really interesting thing to watch as both states and businesses likely challenge the ETS. So what are some takeaways from this sort of preliminary look at litigation? Let's just go through these quickly. First, there's likely to be a lot of litigation, and it's going to get media attention. And I think that your employees are going to be watching and wondering what's happening. And I think businesses would be smart to pay attention to what the courts are doing with the ETS. I think these cases could ultimately reach the Supreme Court. In fact, I think that's likely. One of the big questions will be whether enforcement is stayed during the review process. And that's not a given. A lot of times in suits like this, a state or a business will bring suit. They'll ask the court to stay enforcement of the statute while it's litigated on the merits. And the court goes through an analysis to decide whether to do that. And I'm sure that will be a big initial issue. But I think at the end of the day, businesses would be smart to start preparing to comply with the ETS because I think there could be some initial enforcement. I don't think there's any guarantee that enforcement will be stayed during the review process. And I think that if I had to wager on whether the ETS will be upheld, I think that they likely will. I think the challenges will be serious. I think some circuit courts could rule against OSHA on this, but I ultimately think that these challenges are likely to go up to the Supreme Court and that the ETS are likely to be upheld. I'll also just mention one other thing that I think was interesting. Initially, when we talked about vaccines, we talked to a number of businesses about the fact that OSHA had not required vaccines early on, and the EEOC had said that businesses could require vaccines. And so what that left is for a choice for businesses to decide whether to require vaccines or not. And several businesses that we talked to said, we kind of wish the government would just tell us what we needed to do and allow us to do it. And then we could just move on, because this decision of us having to decide for ourselves whether to require vaccinations or whether not to require vaccinations can be difficult with employees who some feel very strongly that everyone should be vaccinated. Others feel very strongly that they don't want to be vaccinated. And I know that there are some businesses, I think, that are looking to the federal government and saying, well, now we can just say the federal government is requiring us to do this. And so I think you'll see a lot of businesses who start to comply with the mandate immediately, despite the litigation. And I think that will be a trend within the business community, that although the litigation will get a lot of publicity, I do think that we're going to see a wave of compliance. And ultimately, I think the ETS will be upheld. But let me say, I think, there's always a chance. And certainly the past challenges to the ETS show that courts have not been shy in striking them down. So with that, I will turn the time over to Marie to talk about some of the implications of the ETS.
Thanks, Ryan. I think that it's actually really interesting that you said that near the end of your slides, because the first thing I wanted to talk about was what are the options for companies now given the new guidance, or what we anticipate the finalized guidance will say. And really, it's sort of created a dual option, whereas before we talked a lot about a company can choose to require all of its employees to be vaccinated, or it can encourage them to get vaccinated, or it can do nothing. Now that first option has sort of morphed into you can require your employees to be vaccinated, or you can require them to be vaccinated or get tested if they choose not to be vaccinated. And that's coming directly from what we have heard from President Biden regarding what's going to be in the new ETS, where if you have an employee, if your company has more than 100 employees, so you're subject to this rule, and you have employees who don't want to be vaccinated, the rule would allow them to choose weekly testing instead. What's interesting there is that as an employer, you get to choose between those options. So even though we're talking about the ETS requiring companies to do certain things, the truth is you'll still have some choices there as an organization that you'll have to make. So we're going to talk a little bit about the different reasons that you might make one of these different choices. And the first one that we'll talk about is the policy where you're going to require your employees to be vaccinated. So if we could, there we go, thank you. And when you do receive the slide deck later, we have links in the slide deck to the different orders that have already been issued, as well as to the guidance that we currently have regarding what will be in the forthcoming announcement from OSHA. So first of all, just to sort of set the stage a little bit, be aware that in addition to the rules that will be governing companies with more than 100 employees, we also have a new executive order that's going to require healthcare workers at any facilities or organizations that receive Medicare or Medicaid reimbursements to be vaccinated. So even if you're smaller than 100 employees, if you're in the healthcare field, this might apply to your organization. And then also all executive branch federal employees will be required to be vaccinated, as will government contractors. So I don't know that we have any executive branch agencies on the line today, but if you're a government contractor with an agency, there is also a rule in place requiring vaccination for the individuals that you have working on your government contracts. So that's new. And so in all those situations, the new rule is that you must adopt a policy requiring vaccinations for your employees. Where there's some wiggle room is with those organizations that aren't subject to one of those rules, but do have more than 100 employees. They will have to, again, implement a rule either requiring vaccinations or requiring that their employees be tested weekly if they're not going to be vaccinated. One thing that we do know about what will be in that rule is that you'll have to, in your policy, account for the fact that you have to give paid time off for your employees to get vaccinated and to also recover from the vaccination if they do have an adverse reaction. So your paid time off policies will need to be adjusted accordingly if they don't already account for this. We don't know that this will require you to institute additional COVID leave as paid time off. You could, from the guidance that we received from the Department of Labor at this point, you could require them to first exhaust their regular PTO. But if they're out of that PTO, you would need to make more paid time off available to the employees that are going through the vaccination process. So that's something to keep in mind. We've had a few people asking questions about the 100 employee requirement here in terms of how it's going to be counted. That count is done across your entire organization, not across specific work sites. So say you have 50 employees at 3 different work sites, at 50 at each site, you have 150 employees, this rule will apply to your organization. So keep that in mind when you're determining whether, which part of these rules will apply to you. But we're going to mainly focus on those companies that for sure meet this rule. So what will go into your COVID policies in this situation where you have to require vaccinations? The ETS will tell us more about what will have to be in there, but definitely the things that you'll need to address will be who needs to be vaccinated. We anticipate that the rule will say only employees reporting to a work site or otherwise interacting with other individuals as part of their job will have to be vaccinated. So for example, if you have a workforce that is remote in some way and they don't go to the work site owned by your company, or you're not sending them out to other work sites where they're reporting and interacting with individuals elsewhere, it's likely that your policy can allow for those individuals not to be vaccinated. But again, we haven't actually seen the contours of the rule, but this is the kind of thing you'll have to account for in your policy. Who within your organization is covered by the rule requiring vaccinations. Similarly, you'll have to determine how the PTO applies. And that will require, looking at the contours of what's already included in your current policies and then adjusting it as needed. So again, this is going towards, if you're a company that's governed by the rule and you're instituting a requirement for vaccination, whether you're also allowing them to have a testing option is a slightly different question. And so you'll also need to determine whether you're going to put that into your policy where they can choose testing instead of vaccination only. So with that, you'll need to consider the types of employees that you have, your in-person versus your remote or hybrid employees. You'll have to consider also what exemptions are you going to put in place. So Ryan briefly mentioned this when he was talking about the litigation. With the rule, we do know that you will have to allow for medical or religious exemptions. So if individuals working for you, they may have health-related reasons for not getting vaccinated. They may also have a religious reason for not being vaccinated. Those are the only 2 exemptions that would be allowed in this situation under the mandatory rule. And so one of the things you have to think through as a company is what types of exemptions can you create? What types of accommodations can you create for those employees who will seek exemptions? One of the accommodations you might think about is whether they can work from home. A lot of companies have moved a lot of their workforce to a remote status during the last year and a half. And so that may be that becomes an accommodation that you offer to your non-vaccinated employees who are seeking exemptions under this new rule. Another thing you might think about, though, is whether testing might be the option that you allow to provide for covering the accommodations of the exemption. So as an organization, you may actually not want to offer testing as an option. You may say, we're very comfortable with the rule. We're worried about the safety of our workforce. Maybe your workforce comes into high contact with, individuals. Maybe they work in very close quarters. There's reasons that you're particularly concerned. And so you want to enforce a vaccination only rule and you don't want to offer testing. The Department of Labor has indicated that would be fine. You're not required to give the testing option to your employees, but you're allowed to do so. Well, if you're looking at exemptions, maybe you're not giving all of your employees the option to be tested every week. You're saying, no, everybody has to be vaccinated. But then for those employees that come to you and say, well, I need an exemption for this religious or medical reason, you could say, okay, the accommodation we're going to provide is that you will be tested every week. And so it may be that you can rely on that part of the OSHA rule to provide for a reasonable accommodation. One thing that your policy will also have to account for, though, that may be defined by the rule that OSHA will send to us, we don't know yet, but even if it doesn't get defined there, you'll have to determine it for yourself, is your policy will have to determine, who's going to pay for the cost of testing in those situations where you allow testing as an option. Will the company cover it? Will you rely on the free testing that's available in your, different locations? And this is where we do have some information from the Department of Health and Human Services. The Biden administration has announced that there will be increased funding for free testing and an increased number of testing sites. What we don't know is how quickly that will be implemented in terms of increasing the free testing available. And so in the interim, you have to determine, well, what testing will we accept? Will we allow rapid tests to be sufficient? Again, the ETS may tell us whether they're sufficient. We don't know, but your policy will have to address it either way so your employees know what type of testing is allowed. If we're allowing those types of at-home tests, are we going to pay for it? Are we going to cover it? What does the insurance that we currently offer our employees cover? You have to work through the contours of that so that when you send the policy out to your employees, they understand what's required of them. And there's clear communication about who bears the cost. There may be some employees who will change their minds about what option they'll choose between vaccination and submitting to weekly testing based on some of the contours inside of your policy. And so that becomes very important. And honestly, just having run this for my own company, I'm in charge of SixFifty's safety with COVID-related issues and collecting vaccination information and all of that. Clarity of communication is key. Anytime that I send out an announcement to my employees where I have failed to, in the announcement, include the detailed steps of how we're going to accomplish our updated plan, I get inundated with questions, right? At which point I'm like, oh yeah, I just need to send you the updated policy. And so clear communication and putting it into your COVID policy. This will also help you avoid some of the litigation potential. Ryan was talking a lot about the overarching litigation that would be against the mandate itself. But as a company, you could be looking at litigation from your employees if you implement one of these policies, but then you fail to follow it. So, what's in your policy, making sure you're following what's in your policy and making sure that you're being even-handed as you follow the policy becomes very important. Sort of the final thing here to keep in mind with what's in your policies is that you need to outline for employees how you'll be collecting either their vaccination or testing information and what you're going to be doing with it. So notice is very important from a privacy and confidentiality perspective. They need to understand what data you're collecting, what you're going to do with it, how long you're going to keep it. You need to be transparent about those things. And Adrian will talk a lot more about what you actually need to do as you're going through that process. But keep in mind, all of those things need to be outlined in the policy itself to make sure that employees know what's happening and how to comply. So again, this is mainly geared towards if you are requiring testing or vaccination, or requiring vaccination only. Those are sort of the two options under the new rule for companies with 100 or more employees. And with that in mind, you may be wondering if OSHA applies to your company at all. You're like, oh, I have more than 100 employees, but I don't think federal OSHA applies to me. That may be true. So there's jurisdictional rules. Some states have their own OSHA, a state OSHA, as opposed to following federal OSHA. So we have put in for you, for your reference, a slide you can look at to determine whether the states where you have employees are bound by federal OSHA or by a state OSHA. So if you look at this slide, if it's in dark purple and has a little asterisk next to it, that means that you do have a state OSHA in that jurisdiction. That doesn't mean you won't have to worry about this rule. The rule still governs in the sense that state OSHAs have to provide at least as much protection as federal OSHA. So they will be coming out with their own rules in response to the federal ETS that we're going to see. So while the contours of it may be a little bit different, they could be more restrictive in some ways. For example, they may say, oh, it doesn't only apply to companies with 100 employees. We want it to apply to companies with 50 employees. So they might be more restrictive, but they'll be at least as protective of employees as the rules we've been talking about. So keep that in mind. You may be governed by a state OSHA if you're in multiple states, you have employees across multiple states. You may be governed by a combination of both the federal and the different states OSHAs. So keep that in mind and be aware and look for some updates on that. And then, so I'm going to move now into a little bit more information about if you're offering the testing or vaccination option. You're still going to have to provide PTO. So don't think like, oh, if I allow for testing, I don't have to give PTO for vaccination and recovery time. You do still have to provide that PTO. Your policy will need to address differences in office procedures for vaccinated versus unvaccinated individuals. So for example, CDC guidance currently suggests that indoors, both sets of individuals be masked, but it is guidance. So if your company has been following a different set of rules and doesn't want to require masked employees to be vaccinated employees to be masked, for example, you might have a rule in place that does require unvaccinated employees to be masked. So as you sort of determine, are we going to have different rules like that for these different groups of people? Are we going to limit the size of meetings that can be held if unvaccinated, employees are going to be in the meetings? Are there different things, different procedures we want to put in place? And also you'll have different procedures, for example, regarding, how their information's been collected. If somebody has to be tested weekly, you can't give them the sort of carte blanche like they have permission to enter every day, the way you could with a vaccinated individual. So if you're having some sort of security checkpoint or something to make sure people have permission to enter the work site, that process might be a little bit different for unvaccinated versus vaccinated employees. So there's a lot of nuance you need to think through when you're determining what to put into your policy, as well as far as the in-office procedures go. As I mentioned, Adrian's going to talk a little bit about information collection. You'll need more information collection from people choosing the testing option because they have to be tested every week. And then procedures for excluding people from the office if they do test positive for COVID-19. So in a lot of ways, these are things you've been doing throughout the pandemic, but you have to think about it in a little bit more of a nuanced way in terms of how it goes into your policies now. And then finally, well, not quite finally, but if you are not governed by the new ETS and you have the choice to, you might still be choosing to only encourage vaccination as opposed to requiring it for your workforce. And in that situation, the things that need to be in your policies, again, this is only available to small employers as a choice. You'll need to address differences in office procedures. So again, you might be encouraging it, but still have differences in procedures for what vaccinated versus unvaccinated employees need to do to ensure workplace safety and information collection, procedures for testing. So you might, again, not be requiring vaccination, but you might be requiring some sort of daily healthcare screener, some sort of submission of testing information if somebody was exposed to a COVID case and you want them to show a negative test before they come back. Those things are all still valid. They're still available as choices to small employers. You also will need your policy to cover incentives if you're going to allow any incentives for people to be vaccinated. And then the final option is just the option of not having a policy. Again, this is only available to small employers that aren't covered by the new federal rule. This isn't recommended. Honestly, it does leave your company vulnerable. You could have outbreaks of COVID-19, and because you don't have a policy in place, you won't have a good response. You'll be kind of caught off guard and won't have procedures that you can just follow. It makes it harder for you to implement hazard mitigation, which you are required to do under OSHA, even as a small employer. You still have that requirement to provide a safe workplace for your employees. It also leads to employee confusion. If they're not sure whether the people that they're working with are vaccinated or unvaccinated, which may impact their feelings about being able to make informed choices about what they want to do in terms of masking, not masking, asking for permission to report to work remotely, all of those different things. Employee confusion is real. So just having a policy helps them know what to expect and what is expected of them. And then you are probably going to see that there are additional state and county rules outside of OSHA that, again, are going to require you to have some sort of rules in place, whether it's about masking, physical distancing, or limited visitor access to the work site, different things. So we really do recommend some type of policy. And with that, I think that this is the perfect time to learn more about what to do in terms of actually collecting this information. And Adrian's going to kind of help explore the contours of that. So again, the takeaway, you need a policy. If you're more than 100 employees, that policy must either be vaccination or an option between vaccination and being tested every week.
Thank you, Marie. Yes, so after a company decides what kind of policy they're going to have, whether they're going to require vaccination and allow for exemptions, or if they're going to allow both vaccination or weekly testing. Regardless of which approach the company uses, they're going to have to decide how are they going to collect that information about employees' vaccine status. There are kind of three primary methods to do this with variations within each one. The first method to collect employees' vaccine status is to, one, require employees provide proof of vaccination, such as through the actual vaccine card, a copy of the vaccine card, or another healthcare document showing the employee's vaccination status, and the company retains a copy of that document. The second way is that the company requires employees provide proof of vaccination, but the company only maintains a record that the employee presented proof, but not any actual proof of the document itself. And then the third method is that employees self-attest or self-certify that their vaccine status. And this would allow the company to just require the employee's signature or a check mark indicating their status, or the company could ask the employee to provide the name of the vaccine type and the lot number of the vaccination. So those are kind of the three primary methods, but you can see within each one there are some variations. And we originally expected that OSHA would allow companies to collect vaccination status through any of these three mechanisms. So in California, for example, OSHA, which has kind of been the market leader in these regulations that we've seen so far, allows companies to verify their vaccine status by any of these three methods. However, a week ago, OSHA came out with some proposed permanent regulations that would replace the current emergency temporary standards that are in place in California. And these permanent standards would be in place for 2 years, and then they would have to be renewed or replaced. And OSHA is having a meeting today, an advisory committee meeting to discuss these proposed permanent standards. But the key part is that within these draft permanent standards that OSHA released, they define fully vaccinated to mean that the employer has an electronic or physical copy of the vaccine record, stating the name of the vaccine manufacturer and the date of the last dose, including any boosters. So based on this is different than what we've seen in the past and how we thought that OSHA might come out with the ETS. So California is requiring that companies maintain proof of the vaccine status. So that would not allow employees to self-attest to their vaccine status. We don't know yet whether the ETS will follow that new proposed California approach, or whether it will allow companies to use any of these methods to collect an employee's vaccine status. So companies have the wide range to think about right now, but companies should consider, if they're required to retain proof of an employee's vaccine status, how are they going to do that, and what will that look like at the company? And similarly, companies have to, if companies allow testing as an option, they would have to collect testing results. And the way the company collects testing results could be similar to the way the company collects vaccination status, meaning the company could require proof of the testing result and retain a copy of it. The company could require proof but not maintain a copy of it, just indicate that the employee showed a negative test result, or allow employees to just self-attest that they have a negative test result and rely on employees for that one. A company that allows both vaccine and weekly testing might have a different approach for how they collect this information. So vaccine status is typically a one-time event where employees provide that information one time to a company if they're vaccinated, and there's no ongoing documentation unless there are booster requirements that come out, but we don't know how that will look at this point. Whereas testing is weekly, and it's a much more ongoing obligation and much more frequent. So while a company may desire to have proof of vaccination status for those employees that are vaccinated, that company may also decide that not to require proof of weekly testing, so they don't have that same amount and frequency of documentation, because testing will be weekly. So as a company decides which approach to use, the company will have to consider the logistics of this method. So the logistics of collecting this information can be either through company software, such as a surveying tool. It can be on the company intranet. It could be through email. It could be on a non-web-based system where employees are filling out a physical document and submitting it to the company, either electronically or by hand delivery. So the company has a wide variety of options to think about how they're going to collect this information. And for example, we wanted to show you some of the ways that our company that has a return to work tool set, we have a way for companies to collect vaccine information from employees. So we wanted to show you one option of how you could collect this information and some things you might want to start thinking about. So this is a sample survey that companies could send to employees that allows the employee to indicate their vaccination status. And you'll see here, this survey is more robust than just I am vaccinated, or I am not vaccinated. And companies can decide whether they want just a simple approach of, yes, I am fully vaccinated, which means 2 weeks from the final dose of the shot, or I am not vaccinated, and no further information than that. This one digs a little bit deeper and has some more options, such as I am fully vaccinated, I've received 2 doses or 1 dose of the Johnson & Johnson vaccine, but I haven't reached that 2-week mark past the vaccination date, or they've received 1 dose, but they haven't received the 2nd dose yet, or they are not yet vaccinated, but have plans or an appointment to do so, or just they have not been vaccinated, or whether they decline to answer. And these are just sample options that some companies like to ask their employees, but really how the company approaches this is really customizable to the company's workforce, and should be considered of, does the company want to just ask yes or no, or do they want to dig deeper, and would this information be helpful, or is it unnecessary for a particular company? And so on the next slide, if an employee indicates, yes, I am vaccinated, I am fully vaccinated, this is an option in the survey tool where the employee can upload proof of the COVID-19 vaccine card through a secure document retention system. Or on the next slide, you'll see the employee could just self-attest. So this is a self-attestation where employees are asked to provide the date of the 2nd dose and the lot number indicated on the vaccine card. This is, from what we know so far of the ETS, we don't know if this will be required information for the company to collect, but companies should start thinking about, how do we want to collect this information, and what would be the most appropriate way to do so? Especially now, as companies think about which part of whether to do a vaccine only requirement or a vaccine or testing, the analytics of the workforce can be particularly helpful at this juncture for companies as they consider what kind of policy to implement. So on the next slide, one of the tools that we offer allows companies to see the analytics of their workforce. So for example, if the company sent out that prior survey that I showed you indicating the employees' vaccine status, such as fully vaccinated, partially vaccinated, not vaccinated, declined to answer, the company could look at this, could and should be looking and thinking about these things now before a policy is implemented, because it can help a company decide what kind of policy to implement. So for example, if a majority of a company's workforce is already vaccinated, that company might feel very comfortable with implementing a mandatory vaccination policy without the testing option. However, if a company knows that only a portion of their workforce is currently vaccinated, or maybe there's a contingency at the workforce that will never become vaccinated, that company might want to permit weekly testing and decide that now so that they understand what their workforce looks like. And you can even ask employees about their willingness to become vaccinated. Some companies have asked employees, are you currently vaccinated, or do you just, will you ever become vaccinated, and can drill down on that information if it would be helpful in formulating a company's policy. So after companies think about which kind of policy to implement and how to collect the necessary information for that policy, they then need to think about how to retain that information. So on the next slide, there are several different ways and considerations to think about when retaining this sensitive personal information. So first of all, vaccination status or testing status is confidential medical information. So it should be maintained confidentially and separate from an employee's personnel file. And that also means that there are certain retention requirements, both according to the American Disabilities Act and other types of privacy laws. So this information has to be stored securely, and companies need to consider who has access to the information. So companies should restrict access to only those individuals who have a business purpose to see it. So that business purpose could be to track who is in the workforce and ensure that they've met one of either the vaccination or testing requirement. And companies should make sure they have these conversations with supervisors and leaders at the company to make sure they do not ask about employees' vaccination status. That would be an inappropriate question to be asking employees if there's not a business need to know. And that business need should be clearly documented, and employees know where to report their status, but shouldn't be asked outside of those parameters otherwise about their vaccination status. And we don't know yet how long these medical records have to be retained. We know that the current Cal OSHA standard is that the records must be maintained for the length of time necessary to comply with the regulation, which is the current emergency temporary standard in California. However, the new proposed permanent standard in California has a clearer line of the records must be maintained for 2 years beyond the point in which records are necessary to meet the requirements of the proposed regulations. So that gives us a clear standard, because right now in Cal OSHA, companies know that it's somewhere between 1 year, which is a minimum required period, to up to 30 years, which is required for certain medical records. So this gives companies guidance on thinking about how, if they are required to maintain this record for 2 years, what is the most efficient and secure way to do that? So we don't yet know what the ETS standard will be, but companies should maybe be thinking about a 2-year standard that could be potentially in the ETS. So I know we have a lot of questions in the Q&A. Are there some that would be most helpful to talk about live? Ryan and Marie, have you identified some that would be helpful to talk live?
Yeah, I've been looking at the questions, and maybe I could just tee up a couple that have come in batches. We have several that mention HIPAA and concerns about HIPAA compliance. I know, Marie, we've talked about this before. Is that one you want to take a swing at, concerns about HIPAA?
Yeah, sure. The first thing to be aware of with HIPAA is that HIPAA only applies if you're a covered entity. So I know there are a few healthcare organizations on the phone that HIPAA likely does apply to, but the majority of people on the line today are not covered by HIPAA. So HIPAA violations aren't the ones you should be most concerned about in this situation. What you should be concerned about are ADA violations. So you're collecting medical information. And so this puts you in a place where you have to store that information separately from the employee's personnel records, like Adrian was discussing, and you have to keep it confidential. So the confidential part is the hard part, because you're also governing people's access to the work site. So what you need to do is figure out who in the organization has to know this information so that you can follow the procedures And so if they have an employment-based reason to know who is and isn't vaccinated, that's who should get the information. Nobody else in the organization should have access to it.
Thanks, Marie. Yeah, that's a great point. I think we hear a lot about HIPAA, but for most businesses, HIPAA does not apply. It only applies to healthcare related businesses. And so that's an important point. The Americans with Disabilities Act, though, applies to all businesses, and that's something that we need to make sure we're careful with. A second question, or at least thread that runs through a lot of these questions is, what about fake vaccine cards? What, if anything, do I need to do as a business to verify vaccine results, and how can that be handled? I think that's an interesting question that's gotten definitely some play in the media. Adrian or Marie, any thoughts on that issue?
Yeah, I think that, I mean, the Department of Labor has spoken a little bit on some open questions about the ETS, and I have not heard any indications that they would require companies to verify the documentation that employees are provided. I think it would be a different question if it was clearly fraudulent, what the company would need to do in that situation. But it would be a serious burden on companies if they had to verify each vaccine record that employees are providing. And I haven't seen any indication that that would be required.
And I would agree with that. And I would also say, you know, we're looking a lot at Cal OSHA right now, because they already have rules in place that have employers collecting this information. And Cal OSHA has allowed self-attestation, where the employee doesn't even have to show you a copy of the card. They can just tell you, yes, I'm vaccinated. You know, my last shot was on X date. So, you know, it's been at least 2 weeks. So, you know, they're fully vaccinated. So with that sort of being the standard that's currently in place in the most restrictive jurisdiction, I would expect that the new ETS will follow suit and allow self-attestation as opposed to actually having to collect the card. So.
Yeah, I would agree with that. I think it's unlikely that there's going to be a significant burden put on businesses to verify whether vaccine cards are fraudulent or not. I think that would be very difficult for businesses, and I'm not sure that it seems unlikely that they're going to face that type of burden. I think that's more an issue that we may hear about in the press, but I don't see that being a big issue necessarily with the ETS themselves. But I guess we'll see when they come out. There are also some questions about contractors, interns, who is going to be included in these requirements. And I think that's an interesting question. My guess is that contractors will not be included in your employee count. But I would assume that there may be different rules if they're on your work site and you have those rules on your work site. Interns, I think, would probably be subject to the same rules that you have for your employees. But I do think those are interesting issues. I think we're likely to get more information on those when we get the actual ETS. But any thoughts on those issues, contractors and interns?
I would agree with what you said, Ryan. Interns for sure. With recent litigation around interns over the last few years, you need to treat them as much like employees as you can. So in terms of the reasons for these rules, the reasons Cal OSHA is implementing the ETS are based around employee safety. And so if you're doing something for the purpose of protecting your employees, you need to protect your interns in the same way. So for sure, I would have your COVID policies that your organization implements apply to your interns. And contractors, kind of like visitors to your work site. You know, you have a lot of control over that. The main thing that I would look at, and I think I was typing this in response to one of the questions in the chat earlier, is you may have some state-based rules around who you can require vaccination information from. If you are a place of public accommodation, say you're a restaurant or another similar place where you're open to the public, some states do have rules in place that prohibit you from requiring people to show their vaccine status for entry. But that's regarding public accommodation. It's not regarding your vendors, your contractors, your employees. And so I have seen questions around that. Most of the time, if you look at the text of those rules, it is simply regarding public access to your space, not access for people who are under more control, your contractors, your employees. So keep that in mind. You have more control over them than you have over the general public sometimes.
Yeah, and speaking of states and state-specific laws, we did have a question in here about Florida, and I think that the question related to the fact that Florida has some restrictions on when you can ask about vaccination status. Marie, I know you addressed this issue in a past webinar just on Florida's rules.
Yeah, and I would say I haven't checked that one as recently, so there may be a new Florida rule that I'm not thinking about, but the last time that I checked, you could ask your employees and your contractors for this information. It was the public you couldn't ask. And also there are restrictions on what the state can ask. So if a state agency wanted to put in place a rule about requiring vaccination status to enter the premises, that wouldn't be allowed in Florida. But as far as private businesses, you can still ask these questions of your employees and your contractors.
And there's a question in there about conflicts between federal law and state law. Obviously, the Constitution has a supremacy clause, and federal law trumps state law. In the OSHA context, I think what will happen is we'll get the federal ETS, and then the states that have approved OSHA plans, and we have a slide on that, will get to make their own sort of ETS that is at least as protective as the federal ETS. And so there will be some variation in different states, but it won't be a situation where the state OSHA sort of conflicts with federal. That's kind of a different issue, but I don't think that you could have states passing laws that are inconsistent with what OSHA is requiring here, to the extent that was the question. I think we've hit on almost all of these. Any other questions that jump out to either of you? And we can answer some of these also in the follow-up email.
I did notice somebody asked about protections for employers if you're enforcing this mandate and an employee sues you for enforcing it. I thought that might be an interesting one for us to touch on quickly.
Yeah, I think that would be a tough suit to bring. I guess it would be the basis of the suit. Maybe if they suffered an adverse health effect due to the vaccine, which we know is extremely, extremely rare. If that were to happen, I think they would have a tough time suing their employer. I think the employer would be able to say, listen, I was required to do this under federal OSHA requirements. And, there's not a lot I could do here. I think suits against employers who require vaccinations are very unlikely to be successful, but that's just my personal view on that one.
Yeah, I think I'm probably in agreement there. The thing is, we will see these lawsuits, but the question of, who's going to bear responsibility at the end of the day, the lawsuits against the enforceability of the mandate in the first place will come first.
Yep.
And that will impact what happens next.
Yeah. Well, we want to thank everyone for these great questions. It's been an interesting discussion. By my count, we have had 46 questions. So it's been a lively group. We've answered a lot of them in the chat. We will send out the questions and the answers in a follow-up email, but we want to thank all of you for joining us on this SixFifty webinar. We really enjoy presenting this material and answering your questions and thinking about it. If you have any questions about SixFifty and what we may be able to do to help your business, both with a return to work, we have an electronic employee handbook. We also have a quiver full of great privacy tools, including to help business comply with the CCPA, GDPR, and the new PIPL, which will go into effect, which is China's new privacy law, on November 1st. So if you have interest, feel free to check us out at SixFifty.com, and specifically for our return to work products at SixFifty/return to work. And with that, we'll wrap things up. We hope you'll join us in the future for another SixFifty webinar, and that you have a great day.
Thanks, everyone.